Ms Browning.
My Lord, I've been asked to just clarify the situation so far as Natalie was concerned. She was inadvertently included as one of the children in the original application and therefore joined to the proceedings.
Yes.
Therefore, she was represented, and then Her Honour Judge Marshall discharged her from the proceedings when it became clear that she was incorrectly included in the application and that she had no other valid point to make within the proceedings as a party.
She was already 17, wasn't she?
She was, yes. Yeah, no, it was a mistake. And in fact, she was the subject of the police protection order as well, which was slightly unfortunate in circumstances. But,
no doubt somebody's advising her accordingly.
Looking at what we say should be the starting point, can I just consider the issue of the welfare of the child? And in the context, and this feeds directly into my paragraph 47, where I say the welfare of the child is a relevant but not paramount consideration. It links into Mr. Geeky's point about whether a non-subject child, so a child who's simply a witness within proceedings, has Article 8 rights engaged. So I'm not as confident as Mr. Geeky on that. But what I would say is that if the court is considering a child as a witness and in no other capacity, we would say that that child's welfare is relevant, and that probably actually answers the Article 8 point if that's engaged. But when we say welfare of child is relevant, we mean for any child witness, whether a party or no. The way in which we had formulated the factors to be put into the balancing exercise came, as is clear, from paragraph 45 of the Medway case from the judgment of Lady Justice Smith, where she went on to look at the various factors. She's put them in a much more generalised form. We don't have any objection to a more detailed formulation. I can just for a minute. Oops. Okay, my lords have that at tab 4 in the authorities bundle.
Well, she's basically talking about what the extra evidence will bring to the quality of the evidence before the court and the capacity of the court to do justice and reach the right result.
Absolutely.
On the one hand, and the harm that the very process may do to the child on the other.
Yes.
That's basically what she's doing, isn't it?
Absolutely, and we would say that actually the last sentence of paragraph 45 actually would not be necessary if you had the starting point that we suggest, because that builds in the current evidential base in relation to harm to children. But as I say, we don't have any substantive objection to a more detailed formulation as put forward.
That may be the head of the pin on which we're currently dancing, Miss Brannigan. Whether it's a starting point or whether it's a factor which we take for granted because it's so important.
Well, it links into a practical concern I have, and so perhaps it's worth dealing with at this stage. What we don't want to do in my submission is to land ourselves in a situation where this issue becomes a dominating feature of the overall case management. Our concern is that if you do not have a starting point, the court could be confronted with a very detailed inquiry simply about whether a child should give evidence. And that is not what we intend at all. But to pick up a point that Ms Davis made, It is, and without making any assumptions about whether these allegations are right or not, or the propensity of that, if in fact you are a parent who has abused, it is undoubtedly in that party's interest, effectively, to make life as difficult as possible for the child. And we are really concerned about setting up a situation where the court has to hear detailed evidence about what the child feels about this, what the child is thinking about it, potentially the social worker and the guardian being challenged on their analysis of whether this is going to be harmful to a child or not. I'm thinking about a sliding scale of children, whether a child of, say, the age of C is more ahead than her contemporaries and therefore more resilient. We really want to guard against that situation. And we do, and I've said it several times, and I'll say it for the last time, we really do believe that the court has to send the signal that the child is protected in this situation, and that it is going to be for the person seeking that child to give evidence to formulate the particular reasons. And I think that's the way it has to be if we're going to keep this within its proper bounds.
I don't get the impression from the judge's judgment in this case that it's an easy decision, even under the present law. So I mean, I don't know how long it took to argue the case in front of her.
No, I don't, I'm afraid.
But how long did...
Certainly, written submissions had to be presented for that. We certainly presented a position statement for the hearing on the 23rd of October, which I think was then amplified on a second occasion.
Yes.
Could we, just thinking about the factors that may be placed into the balance, we would probably say that the quality of the ABE interview comes high up the list. Clearly, if you have a well-conducted interview, that is going to be an important part in the balancing exercise, we suggest, and equally a poorly conducted interview would tend towards an argument that the child should be called.
Could you switch your other machine on as well?
Oh, I'm so sorry. I'm so sorry. We also think that the nature of the challenge to the allegations is important, and it picks up on the keeping your powder dry issue. If you have a parent who has formulated sensibly and clearly a series of challenges to the evidence, again, that would weigh, we submit, in the balance. If you have a parent who simply said, well, it's all a lie, and is silent in every other respect, that those are the two sort of polar parts of the argument. But it may be that the nature of the challenges would be an issue to be taken into account.
It's not the nature of the child's allegation, it's the nature of the father's response.
Yes.
Absolutely,
Yes.
absolutely.
If he's saying that can't be right because...
Exactly.
And that's something you really need to know what the child has to say about that. This is without prejudice to how you go about it.
Yes.
Because it seems to me there are many, many ways in which one could go about that.
Yes.
But that's a very different question from his saying, oh, she's always been a liar, she's telling lies, it's all a tissue of lies, and I'm not going to tell you why I say it's all a tissue of lies.
And I think that also gives you a sense of the person that you're dealing with. You know, are they looking at this as an opportunity to make life as difficult as possible for the complainant? Or do we have a genuine situation where the court really needs to be looking at the quality of the challenge and assessing that evidence? And we do think that's an important part of this. And it may be that that direction needs to be incorporated at the preliminary hearing, where you're looking for a response to those allegations.
Where do you say the challenge in this case falls on the spectrum between what you've described as the two polar points.
In terms of the statement filed within these proceedings, it says it's untrue. Having said that, there is the father's interview with the police. And he has also, provided for the forensic scientists an account, and I'm not quite sure how this has come about because I'm not in the proceedings as a whole, and the bundle as a whole is not here. But he has formulated his explanation for the semen being on the skirt.
It's not likely that the child would be cross-examined about that, surely.
Well, one would absolutely hope not. And as I understand it, the forensic scientist is warned. And so, but just thinking about that for a moment, if the forensic scientist says that's an extremely unlikely explanation, and we know that that's her position, we haven't had any sense of where the alternative lies. And so the answer to the question is, I think in this case, somewhere between the two. We don't have a very detailed excursus, but we do have the interview and we have some information. What we don't have, and this isn't a criticism of the father, but what we don't have is any sort of response to the allegations of physical abuse. And I think might have our own views about the case management of it, but there it is. That is the factual situation at the moment as it stands. And nor do we have any detail from the mother about what she says about the allegations that C has made in respect of domestic violence to her and things that she's seen. We just have from Mum. I think some of it's probably right. And I've shifted my position to that extent. I don't know if that's helpful or not, but I think we're sort of halfway between the two ends of the spectrum here. We would also say that the factors should include the observation that a reluctant child should not be forced to give evidence. Now, how that... We'd sort of put it above the line, if I can put it in that way, because it's included in my bullet points at 47. On reflection, it may well be that that sinks below the line in terms of factors.
That's on the harm side of the equation, isn't it?
It is on the harm side.
Your first three factors were on the will it improve the quality of the evidence before me. This is a harm factor.
It is a harm. Yeah. Now, from my statement of case, and I think from the arguments that put forward by the local authority, I think the court understands where we stand in general terms about C and her evidence. We align ourselves with the arguments that are made that the law as it currently stands was properly applied by this judge, and there's no challenge to that in this court. The question is whether you shift the goalposts. And I think what we would say is it's the degree of movement that is probably going to determine whether the decision per se can stand or whether it needs to be re-referred to the first instance judge. And obviously we've queried whether that judge in fact can be Judge Marshall. Not for, I don't want to be in any way offensive to the learned judge, it's simply that she has taken a quite clear view in this case about whether or not she needs to hear the child. And I think in so doing, she has certainly given some indication about where she feels the truth of it may lie. And in those circumstances, it may well be it's proper for somebody else to look at it afresh. But we don't necessarily invite specific reference to that. But I think it's an issue.
Well, we've got a number of possible choices, haven't we?
Yeah.
One is we simply dismiss the appeal.
Yes.
Things go ahead on Monday as planned. Another is that we allow the appeal and say this discretion has to be exercised afresh.
Yes.
Now, if we were to do that, the question would arise, can we ask Judge Marshall to reconsider matters in the light of the judgment of the court, bearing in mind, and I mean, I have to say that whatever the criticisms that can be made of her judgment or of the present state of the law, and of course I have read with care what Lord Justice Rymer had to say about it, this was, it seems to me, a pretty full and careful consideration of the issues, whether it reached the right result or whether it gave the right weight to the right things. I haven't read a lot of judges who've taken as much care of this sort of issue as she did. If she were able to revisit the issue at the outset of the hearing on Monday, and supposing she were to come to the conclusion that having looked at whatever this court says, she had perhaps given too much weight to one factor and not enough, or applied the wrong starting point or whatever, and therefore decided that she would ask that Charlotte give evidence. What would the Guardian's view of that be? I know that Charlotte has not been told that we're talking about her today, but we do need to know what the Guardian's view would be.
And I can tell the court exactly what that is. Can I just put it in its historical context? When the court was considering between the 23rd of October and the 25th of November the question of whether C should give evidence, the Guardian and her solicitor visited C specifically to ask her view about giving evidence twice. I think the issue was, we tried to make it as straightforward as possible and simply said that an issue had recently arisen about whether or not she should give evidence in both proceedings. She was told that evidence within the care proceedings was a possibility only. She said that she would prefer not to, that is, give evidence twice, but would do so.
But would what?
But would do so if required. And the phrase that she used, which I think is a matter of concern to the Guardian, is she was saying, well, she could use it as a practice run for the criminal proceedings.
Well, I don't personally find that very surprising.
No.
Her reaction sounds entirely commonsensical.
Absolutely. But I think what it does highlight is precisely the point about actually you can't take necessarily what the child is saying at its face value, because we would say a child who's saying, well, it's a practice run for the real thing, probably doesn't have a proper appreciation of what's in store for her. That would be our concern about it. So that
then it's a separate issue what's in store for her.
Yes.
Because one of the things that we've been emphasising with counsel throughout is that there's more than one way
Yes.
of confronting this situation. Yeah. And it doesn't necessarily entail counsel for the father putting questions directly to her. There are other ways of doing it, and still enabling him to put whatever precise challenge he may have.
Yeah.
And you've identified one example.
Yes.
Where she actually says what happened in her interviews, I recall.
Yes.
She says what happens. Well, he might want to put to her, well, no, didn't I do this? There are various ways of doing that. So,
I mean, I think that's absolutely right. I think the difficulty is, of course, that those ideas are embryonic so far as the family justice system is concerned. We simply haven't addressed our minds to it. But I entirely agree, there are other ways, there are various ways of doing it. What has happened subsequently is that she was told by the Guardian by telephone of the outcome of the Court of Appeal hearing.
This is paragraph 23 of your note, I
is.
think, isn't it?
And it's the reason I included it, because I know we shouldn't overburden with facts, but it seemed important. And it particularly seemed important to me because I was struggling when I first came into this, not many days ago, to understand how it was that this sort of wodge of information had been forthcoming on the 22nd of December about the physical abuse. You know, what had triggered that? My speculation, it was speculation only, was that having been told she wasn't going to give evidence for whatever reason, it then came out.
Well, I mean, that does seem rather odd. Why should it make any difference to her producing this information, whether or not she's going to give evidence in the care proceedings? She knows she's going to give evidence in the criminal proceedings, and she said she's, or indicated she's fairly relaxed about giving evidence twice, although not surprisingly she said she'd prefer not to. I don't quite understand where this is going at the moment.
I think there's a real difference for her in terms of making allegations that relate to her and allegations that bring in wider members of the family. And that was really the striking thing about the second interview, was that in interview one it was all about her. It was contained, she was going to deal with it. The allegations are much, much broader in the second. And I think there was a real... Our worry is that she's got a concern that if she says these things that happened to her mother, it then puts her mother into the position of having to be in direct conflict with the father or the stepfather. And of course, that inevitably happened as a result of the first interview, but it was much more direct in terms of the second interview and implicating the other children and bringing them into the arena. And I think that's simply our sort of amateur look at it from our standpoint.
I mean, can we go back to the original point as to the possibilities as to the way the case might go? I mean, one possibility is the one that my lady was mentioning, that if, of course, I mean, she's dealt with two, where either the appeal fails. If the appeal succeeds, then it goes back to Judge Marshall, or you say possibly not Judge Marshall. That's one possibility. Another possibility, I notice in the case involving Lady Justice Smith, the court actually was invited and did decide the issue of discretion itself, which is what
Yes.
Miss Earley was suggesting. What's your position?
Well, can I tell you what the child's position is now, which is that there was a real explosion, as I understand it, of emotions post the 13th of January interview, with the suggestion that she just wanted to wash her hands of it all. The Guardian's sense is that she's come back from that point. She's certainly more reluctant and more ambivalent about the issue of giving evidence now. The question I posed to the Guardian was if this court or another court said that she had to give evidence in the care proceedings, whether that's something that the Guardian felt that she could effect. So whether she could persuade C that that's what she should do. I think she feels that she could. But I think she's concerned that post-care, it's much less likely that she'll feel confident in the criminal proceedings. So that's her assessment of it at the moment.
Are you going to be involved next week?
No, but my junior is. Miss Jones will be. To the question of whether this court should exercise its discretion, I think we would say it depends on the extent to which the current applicable principles are going to be revisited. And I know
If
that's
we get
a
it right,
cop-out.
you're happy for us to do it. But
Yeah.
if we don't, you're...
Exactly.
You'd rather we sent it back to a real judge who knew who knew about these things.
I'm not sure about a real judge, but I think because we do see it very much as a case management issue and something that's got to be kept under review, I think we feel the further we depart from where we are currently, the more appropriate it is for the first instance judge to make that
I
determination.
mean, how late in a 4 or 5 day hearing could it be decided if it was revisited by the judge?
I think the problem is the preparation. And of course, again, we've only got the special measures to take as a guidance, but you certainly would not normally anticipate telling a child, even today, in anticipation of 3 working days before the start of the trial, that it was required to give evidence and then do all that familiarisation. That is a longer piece of work, even for a child who is reasonably confident about giving evidence.
Sorry, it's a familiarisation with the video link, is
Yes,
it?
And certainly the recommendation is the child should have a visit to the court, should practice, if at all possible, on the link. She's going to have to review her interviews, which are 4 discs in all and quite lengthy. And because she's got, at the moment, no idea that she may be required to give evidence next week, and that's a decision we just had to take. Do we tell her about the Supreme Court or not? And the decision, a joint decision between us and the local authority, was not, because we just weren't confident that she could take on board the implications of that. So we are in a position where she's completely ignorant of everything that's been going on. And I think we would say on welfare for C that if she is to give evidence in the proceedings, we think next week is going to be too soon. And certainly we would be very concerned that we couldn't do a proper preparatory job with her to ensure that that was as least harmful experience for her as possible.
Well, let's just think of this is obviously thinking worst case scenario from your point of view. So we reach a considerably different conclusion on the law. We think that the only thing for us to do is to exercise the discretion ourselves, because otherwise it's going to build in enormous amounts of delay. And we decide that she should give evidence, which is going to be worse. Putting off the fact-finding hearing until May, or a very swift and skillful piece of work by the Guardian and social workers. That's a worst case scenario from your point of view. I completely understand that, but I'm putting it to you because we need to know the answer.
Can I turn my back for a moment? Guardian's view is that from C's point of view, a delay to May would be the worst case scenario. That she would understand if we went to her and said, because of the decision that's been made, we haven't got very much time, so we need to do X, Y, and Z. And she thinks that intellectually she'd be able to process that. Whether emotionally she's going to be able to process it, we have no idea. But from her perspective, she's incredibly concerned about delay for the siblings. She's very worried about her siblings.
Just to mention another hypothetical possibility, if this court were to allow the appeal and send the matter back to Judge Marshall for her to revisit her decision in the light of our judgment, it is most undesirable that too much of those 5 precious days should be spent in making submissions to the judge. I would have thought I was speaking just entirely for myself now. It seems to me that the judge, if that were to happen, should be given a copy of our judgment at the earliest possible moment, and that she should invite strictly time-limited submissions as to what she ought to do. But if that were to happen, of course it's for case management for her to decide how long to spend on it, but if she were, she probably would want to know what C's attitude was, so far as anyone could tell her, on Monday morning, wouldn't
Yes,
it?
I mean, we would certainly do that piece of it. As I say, it was a decision that we took, but we're certainly not hugely fearful about an adverse reaction if we went to her and said, look, the decision's been reviewed. I don't think we'd probably even put it in the context of the Supreme Court. We'd simply say that the decision had been reviewed, and that she was needed to give evidence, and we'll need to sort of put her through the preliminary bits reasonably rapidly.
Some 14-year-olds would be proud to be making law in the Supreme Court.
Yeah, well, we'll probably tell her about it later on, but I'm not sure that in the context of what she's got to make sense of immediately.
Absolutely.
I mean, I'm sure we'll have the wider discussion in due course, but I think if she's got to make sense of a situation where she has now understood for some months that she hasn't got to give evidence, that's changed, and next week's the week. I think there's a limit to what we should be telling her at this stage, and how she should make sense of that.
I'm sorry, if the matter on my lord scenario is to go back to the judge for her to decide afresh on Monday, I mean, between now and Monday, or presumably in order to make it a real possibility the child could then give evidence if the judge so exercises her discretion afresh, the child will have to be informed ASAP and started, and
Oh, absolutely, yes.
the training process would have to start.
Yeah, we wouldn't delay in those circumstances, and we'd tell her that in fact she may be required, and we want to show her the court. And we would do that. This guardian would undertake that. She has a good relationship with this child, as does in fact the social worker. Simply the practical point that I would want to be clear about before we undertook that exercise is that in fact there's going to be a video link available at Portsmouth, because we have no idea about that. We have to book the criminal court in order to do that, and so that information would have to be fed in.
What concerns me is, I mean, it took 2 months to sort out this issue and get a very comprehensive judgment last time.
Yeah.
If we send it back now, despite what my lord said, isn't there a real risk that an awful lot of time is going to be taken, and then on Monday the judge is going to want to take time to put her reasons in writing, and inevitably next week would be at risk. And there's the additional factor that if we send it back now, you will have to tell C of a risk. What's she going to think of the legal system? It goes one way or another like an electric switch, and then she's got to be in suspense for a week, and maybe the switch is turned off again and she's not giving evidence on Tuesday. I just wonder whether it's very realistic to send it back and keep the date.
Yeah, I mean, there are risks attendant on all of that. But we have got to keep C central to the considerations. And if...
Well, what I'm suggesting, I mean, I'm just coming back to the point that I put before, and it may be that I'm overlooking something, but wouldn't it be better to have a decision now, if we got to that point?
Yes, but what I'm, and I absolutely accept that as a matter of principle, what I'm saying is that we shouldn't shoehorn the decision into that. If in fact your Lordship's decision moves significantly away from where we are, and we have to look at completely different applications of discretion. That's the only thing that concerns me about it. I fully recognise the faults of the point. It's going to depend, I'm afraid, on where the decision falls in due course. But we have to keep C central to the consideration.
Which is why I asked about
Yes.
her comparative, or the Guardian's view of her comparative view of delaying next week's
Yes.
hearing,
And
as
you have an
against
answer to
being faced with the sudden
Yeah.
requirement that people might want to put some questions to her. I'm keeping an open mind about how that might be done.
Yes, and I don't think we're particularly driving any point. At the conclusion of my submission, I put forward a series of propositions. I don't think any of them is necessarily perfect or imperfect. It's we're where we are on the timetable, and I think we've got to do the best we can, provided the best we can doesn't cross a line which then becomes inimical to C's welfare.
I mean, the video link, you only need it for an hour at most. I mean, you could, I don't know, I mean, nobody's obviously asked the court at Portsmouth, how, you know, whether that court is free, but I mean, you would only need it free for a very short time, wouldn't you?
Well, I think it very much, I'm not sure that's necessarily right, because of course the physical allegations now involve the mother's team fairly significant. If the mother's position is that she denies the reported violence meted on her and the children in her presence, that's a detailed piece of cross-examination. I'd frankly be astonished if you were looking at less than half a day.
How can you cross-examine on that? I mean, one doesn't know what the allegations are, but it sounds like the sort of cross-examination which says it didn't happen. How that can go on, especially with a child, for any length of time, I find difficult.
Well, yeah, I mean, it does. I'm afraid it does. And
Well, that may be a very good reason why people shouldn't be allowed to cross-examine too very often.
Yes.
But if it happens, but it sounds as if it's a cultural.
This is one of the reasons why I keep on saying that direct questioning is not necessarily the right answer in these questions. What might be the right answer is formulating precise points of challenge to precise points made by the child, and enabling simply those to be put, maybe by counsel for father, maybe by counsel for mother, or through an intermediary who might be the judge, who might be somebody else, rather than, but questions in advance, rather than the sort of fishing type cross-examination that we're all too familiar with.
And I think for me that's where we produced the case of SM in Sweden, and we rather like that suggestion actually. I mean it's very analogous to the unimplemented Section 28, but a situation where a child is asked a series of questions in a videoed interview, we think could be a very significantly positive way forward when you're looking at these sorts of issues in reality. I think it's not about a child not being challenged. That's not the concern. It's not about blindly accepting what children say. What I think the real fear is that children will be exposed to use your ladyship's words, a fishing exercise, particularly when you're looking over your shoulder at criminal proceedings, because as night follows day, there'll be applications for that evidence to be transcribed, so that when the child says something slightly different in the criminal proceedings, previous inconsistent statement will be put. I'm afraid we can see all of that as part of the
Think of it as an old-style committal. That's what he really wants.
Yes. And
So
certainly,
that may be an unduly cynical remark, and I
No.
apologise to Mr. Geeky's client.
but it may well be that sits more happily, in a sense, between the competing Article 6 rights, which stepfather undoubtedly has, and this child. And I think the problem is that we do tend to think in terms of that very stylised cross-examination that one is familiar with in the criminal situation. And I think we potentially have a huge opportunity to take things forward in terms of how we think about the reception of evidence and how we challenge and how parents can legitimately challenge the children without it turning into that sort of practice run for the criminal proceedings. Let's see if I can answer his questions. That is completely inappropriate for the child. And so I think there is an opportunity here. We would say it's an opportunity that, at least in parts, got to be informed by the work from the Family Justice Council. But why not strike out and say, you didn't implement Pigott, but we think it's a good idea in terms of the unimplemented Section 28. We're not confined by the statute. Let's grasp it. And it's about how you make those sorts of imaginative proposals for children. And I think from where we stand, that's, I think, ideally where Ms Jones and I would have liked to have taken our thinking in the course of these submissions, but your Lordships knows about the time constraints. And that's the sort of thing that we would have been looking to do with a longer lead-in period.
Yes, well, we're not going to have time, I think, to preempt the entire work of the Family Justice Council.
But it may well be that this court can say, we have got some opportunities, let's think about them. But it's what you do in the meantime and how far you go that is our concern. And I think that's reflected very clearly on our case statement, and I hope through submissions through me. Can I just... The only other invitation I have for this court relates to something that has been gone over time and time again by the Court of Appeal, but it's simply not happening, which is that about the liaison between care and criminal judges. And it's a hackneyed old horse, I know. And Lord Justice Wall in Re-W...
If Lord Justice Wall can't get his own way in this matter, I'm not sure that the Supreme Court can.
It is like banging your head against a brick wall. We know very little of what's happening in the criminal case. I don't think we even know who the allocated judge is for this case. And I don't know whether it helps or not, but it is frustrating that the expectation is of closer liaison, which is simply not taking place. So I don't know whether your Lordships would feel it's appropriate to make a comment about it,
well,
but we would certainly
Lady
invite
Hale, I'm sure, is very, very aware of this problem, and the rest of us are to a lesser extent. But we cannot, I think, solve all that in our judgment today, and we have quite a lot of other things that we are going to have to try and solve.
I was a little bit puzzled in the Lord Judge's judgment in the case that we were looking at. Levy, is it?
Levy,
Yeah.
is that the one that's in my four-paper buildings
yes, that's right,
file?
yes, which I have extracted and put somewhere else, which I have now lost. Was it in this one, or was it in... Yes, and quoted by Lord Justice Wall, which suggests that the first joint directions, practice direction in London was in 1993. I think it must have been later than that.
I think it was.
Because it was when I was liaison judge for London.
Right.
And His Honour Judge Hyams, who was the recorder of London, and who had been the designated family judge in Norfolk, in Norwich, got together to try and produce a practice direction for London. Probably without much practical success, but we certainly tried. We produced one, so I think it's later than 93.
I think it is later than that, but it's certainly been on the agenda for a while, that's for sure. But, you know, the sort of situation that His Honour Judge Crime was faced with when you've got the care and the crime converging into the one space in the timetable, one would have to say, you know, it's sensible for the two judges to be talking to each other to see the best way through in a particular case. And delay is always the problem. But
why don't you know?
Why don't we know about the crime?
Who's got the crime? Is it because nobody's got it? Or is it because the court service won't tell you?
There isn't an allocated judge, you're saying? Yeah. Right. So it doesn't appear that there's an allocated judge. And of course there was an adjourned, I want to say case management conference. I don't know whether that shows me age, but there's certainly an adjourned hearing, and I have no idea why that was adjourned either. And it does reflect a problem. Lady, my lords, I don't know if I can assist any further on behalf of the
Thank you,
child
you've been
and children.
very helpful, Ms Brannigan. Thank you very much. Ms Jones? Mr Geekley?
My Lord, may I just tell the court it's a simple matter of information which doesn't seem to me to be relevant, but in case anyone thinks it is. In fact, I am not able to represent this appellant at the hearing on the 8th of March. When it had to be put over on the 4th of January, I was already engaged in a part-heard matter, and Judge Marshall knew that. My Lord, overnight we produced for the court the up-to-date version of the AB...
But will Mr Liebrecht be appearing?
No, the funding in the court below has been leading counsel only. Mr Liebrecht's assistance is for this hearing only. Alternative leading counsel is in place and ready for whatever comes.
Thank you.
Overnight, my Lord, we provided the ABE interview, the up-to-date ABE interview document. I believe you will have that. It's updated on that one, my lady. The one we handed in was the prior one because it was only just before coming to court we realised that the wrong one was in the bundle. So
Yes.
that's been updated now.
Some very kind person left this for me.
Yes.
But you better have, now that we've got the photocopies, you better have the original back.
Thank you. Put it in the history file. Thank you.
I scanned this for any indication of when it was actually published. It seems to be a modern government habit to suppress any date when a document comes out.
Yes.
It seems to have been...
No, that's the old one, lady. That one has the date, and I think the best one from this
2001.
is
This refers to a code of practice that came in force in April 2006, so it's sometime after that, but...
Yes.
Page 9 of the foreword is the little Roman 9, is the best indication.
Or 10, the 2007 revision.
Oh, yes.
I believe it may be that is what this is,
So this is 2007, probably.
or thereafter, yes. That, yes. Right. My Lord, similarly, we provided to the court the relevant part of the Civil Evidence Act 1995, just so the court had before it the provisions of section 4, subsection 2. I don't propose to go to those,
Yes,
simply
thank you.
provided those in the light of submissions that have been made. My Lord, may I make brief comment upon just a few matters that have been raised. Firstly, the discussion that has taken place in relation to the ABE interview and its status as the best evidence. I don't contend the proposition for one moment that in the case of a child who has been abused, it is likely to be the best evidence. But the difficulty as we apprehend it is that it does not deal with the difficulty of testing of an account which may not be true. So that is the heart of the difficulty. For those cases where there really is an issue as to reliability, the ABE interview, because of the careful manner in which it is produced, may disguise rather than reveal difficulties. And may I just say a word about some of the exchanges that took place in relation to what was styled, very loosely I appreciate, the Old Bailey cross-examination, but certainly I'm sure we all understood what was intended by that loose styling. In a criminal case, it may well be that there are limitations upon the degree to which a Crown Court judge can intervene, and the reasons for that are particular to the jury trial. But in the family case, we certainly would accept that a family judge has a continuing duty to safeguard the welfare of a child who is a child witness. And in those circumstances, in the way that was canvassed to a degree in submissions, I think particularly between myself and my Lord Kerr, it would be the duty, or certainly available to, and probably the duty of the family judge to be more interventionist in relation to the way in which cross-examination is conducted. And certainly, if one is, I appreciate my lady has raise other matters about how these things can be done, and I'll come to that in just a moment. But if one is thinking in terms of cross-examination, albeit through a live link, this court could make clear, we would submit, that it is the duty of the judge to continue to control the process. An allied point to that is the point that I made yesterday about the status of the child who is a simple witness, what I call the stranger child, and that any Article 8 rights they have. The way in which I hope, or certainly intended to put that, is that it's that individual, that child before the court, has a right to respect for private life, and these processes are intrusive into private life. So to that extent, that child has, the court has to look to that child's right. That consideration will be considerably more circumscribed than when one is the subject child. But the point is that in the case of any child witness before the court, the judge would have a continuing duty and therefore would be obliged to have control over the way in which the cross-examination proceeds. So that the child...
The real trouble in these cases is that in the absence of any actual positive explanation or positive case, I suppose there may be a positive case in the present case in the sense that whatever you said is motivated by jealousy, right? But in the absence of any positive case about the alleged facts, cross-examination usually reduces itself to asking the witness to go through the whole story all over again and then hoping that in some respects the account is slightly inconsistent and then building on them. And that is a very lengthy exercise and I've often thought entirely unproductive, but maybe in some cases.
I recognise the difficulty, my lord, and don't disagree that is what sometimes occurs. Whether it should do or not is perhaps a different matter, but I would respectfully submit that often the more important and perhaps more effective cross-examination is when one is looking at surrounding details. Because if these cases have background, and if there are surrounding details that are not credible or don't conflict with our other evidence, that can sometimes give a road into an understanding more about what the child has had to say.
What I understand, I mean, what I've actually, I think, to some extent seen on the continent is where the questioning is actually done by a judge, and it may be with an intermediary with the same. The witness is, in fact, effectively given their previous story and then asked supplementary questions on the assumption, on the basis of that. And I think to an English cross-examiner, that's giving too much away in the sense you're helping the witness too much, might be the view, but it was certainly a much shorter process. You say, judge says, you said this before, now I want to ask you just these questions. But I mean, it seemed to me with a child that might be quite an appropriate way of dealing with it, but it may be it's anathema to someone in your position.
Well, I would suggest that many family advocates would recognise that long and head-on conflicted cross-examination about the details of the event itself may be very unproductive. It may have a different impact upon it in front of a jury, I don't know. But many take the view that to examine surrounding detail, to examine points which can reveal whether the child is reliable or not and can reveal context and background, can be more productive. And the point about that cross-examination is it's less likely to be traumatising for the child. It's not, one of the key concerns, of course, is asking the child to have to relive the event. And that is a supremely sensitive arena. But other questions which can be revealing, can be illuminating for the tribunal, can be in relation to aspects which are less difficult for the child. And so I simply invite the court not to approach it on the basis of it has to be a you did, you didn't in relation to the events themselves, but there can be much more that can be revealed and of assistance to the tribunal of fact. My Lord, my Lady, turning to the alternative to proposals about other means in which this might be done, I've made submission already in relation to what we say about the standing or position of the work to be done by the Family Justice Council in relation to this hearing. I don't propose to go over that submission again. The court has our position on that. Of course, I would accept that the Family Justice Council will be able to not only provide a depth and breadth of evidence, but also that they will be able to advise on policy and practice, and all of that might inform future practice. But what has been, in a sense, canvassed before this court in the course of yesterday afternoon and today is the possibility of some form of Section 28 of the Youth Justice Act, which has not been brought in crime, of the pre-recorded cross-examination, being deployed within family proceedings. And my Lord, I simply say in relation to that, that does seem to us, with respect, to involve such broad issues of policy and practice that although it might be something upon which this court could pass comment as to the virtue of further investigation, as indeed did Lord Justice Wall in S&W and W, we would respectfully suggest it would be, it's difficult to see how it could be a direct outcome of a hearing such as this, which is concentrating upon a specific legal test. May I just touch briefly on a couple of final short subjects. The question has arisen about the father's position in relation to any further application arising out of the interview of the child on the 13th of January. My Lord, it's been quite impossible to contemplate putting that issue before Judge Marshall, because at all stages since the 13th of January, the question as to the appropriate test that Judge Marshall should have to apply if she had to reconsider the matter has been under judicial scrutiny. As at the 13th of January, the Court of Appeal decision was pending. That was promulgated, I believe, on the 9th of February, and within days of that, this court had granted permission for the matter to come back to this court. So it would have been quite impossible to invite Judge Marshall to reconsider that issue without her having available to her the test that she should apply.
Nobody's suggesting otherwise.
Perhaps I misunderstood, but I thought there was a suggestion that the father perhaps should have taken it back in relation to that. If I misunderstood that, then
I think there may have been a bit of a suggestion.
Non-issue, very well. Yeah. Finally, my Lord, the question of private law proceedings, as touched upon by Ms Brannigan, I believe in our written documentation we recognised that the issues that were raised arising from this specific case were likely to have equal ramifications for private law proceedings, and certainly it would be consistent and right that whatever test there is should be applied equally in each, is our submission. We also recognise, and did so in the documents, the additional particular difficulties that touch upon private law proceedings, because very often the parents are not represented, and any account from the child does not come through independent sources in the way that it does in public law proceedings, and those are very real difficulties. I don't dissent from that. We also pointed out in our document that a similar situation or analogous situation can arise in public law proceedings, where often now you have interveners who are individuals who have been alleged to have done acts and are joined to the proceedings to make their representations in relation to those matters, and they, for similar reasons of public funding, will not have lawyers representing them. So it's a situation that does arise in public proceedings as well. The additional difficulty for private law proceedings, as noted by Ms Brannigan, is that it is recognised by many that the nature of the conflict in private law proceedings is perhaps the most fertile ground for false allegations to be made. So these issues are acutely difficult in private law proceedings. And I don't speak against any of the particular points Ms Brannigan made about that. We would in large part agree as to the sensitivities and difficulties. All we could say is this, that it must be right in our submission that the same tests must be applied, and individual judges in individual cases will have to factor in all those elements to which Ms Brannigan adverted, in particular whether or not an individual parent in person will be cross-examining will have to be part of the evaluation. But I don't know if Ms Brannigan was suggesting anything else, but we would certainly submit that a single test would need to apply across all relevant proceedings. My Lord, those are the only matters I wish to raise in reply.
Thank you very much.
Can I just ask, I mean, what is your attitude about who should make the decision if one were in your favour?
My Lord, There are recorded for this court, both in the judgment of Her Honour Judge Marshall and the judgment of the Court of Appeal, the facts as found in relation to this case. We submit that, somewhat depending upon how you style any judgment, this court could say, on those facts, this child should give evidence. But it may be that your judgment would be such that it indicated that additional matters needed to be taken into consideration, and in that situation we would accept that it would be very difficult for this court to exercise a primary discretion on factors as yet unknown.
I'm sorry, could I just, forgive me for interrupting, is that additional to the facts as found or additional to the material that we have considered?
When I was saying that, I was thinking of additional to the facts as found, but this court could, if it saw appropriate, look to additional facts as shown in the papers, but the more one is just deriving it from the papers rather than the trial judge's primary position hearing primary submissions, the more difficult I would respectfully submit it becomes to exercise the discretion afresh.
So in principle, this sort of discretion is exercised on the basis of the material that the court has. The court isn't making up its mind about issues of fact. The court's just doing the best it can on the basis of the material that it has before it. It's a case management decision.
Yes, and that's why I'm not taking a particularly firm line on this,
Yes,
but
right.
if the judgment of this court was such that it said that additional factors which don't appear anywhere should have been taken into account and need to be laid before a judge of first instance, that perhaps pushes this beyond a certain line.
If we were to say that we would need psychological evidence, expert evidence as to the harm that this particular child might suffer, well, that's the sort of thing you have in mind.
Yes, I have in mind that we say there was no direct evidence as to any particular harm for this child, but I hope, my lord, my lady, that's not ducking the question, but it's simply saying that on the facts as found, certainly you could deal with it. It may be that you say more would need to be taken into account.
So that's it.
Thank you.
Thank you. Well, the court is very grateful to all those who've been involved in presenting this important and difficult appeal at short notice, whether you've made all submissions to us or not. And we will consider our decision, and we will immediately proceed to considering what I might call the logistics of how we're going to get it out. I think it probably would be useful if someone from each team could remain available for the next half hour. That's not to say we're going to give a decision within half an hour, but we may be in a position to tell you when we are going to do it. And that's not to say you need to stay in court or anything like that, but if someone from each side could be around for half an hour, we'll... Yes. And it is likely, not certain, but likely that what we announce in half an hour will involve having someone here tomorrow morning. But we'll give you further information about that as soon as we can.
Well, thank you. Well, so long as it's counsel for each party, would the court be content?
I thought I said that, yes.
I'm sorry.
What did I say?
No, you probably did, and I was immediately just thinking of a commitment tomorrow morning, which...
Somebody from
Thank you.
each party, I think my lord
Yeah,
said
I think it would be useful if someone from each party could be around for the next half hour, and it is likely that someone from each party should be here tomorrow morning.
I'm sure it was clear first time. Thank you.
Thank you. Right. The court has reached a unanimous decision as to the disposal of this appeal for reasons that we hope to hand down in writing at 9:45 tomorrow. And the order we propose to make, and this obviously is subject to comments on drafting, but they can be dealt with tomorrow. The order we propose to make is, 1, the appeal be allowed. 2, the fact-finding hearing fixed in the Portsmouth County Court for the 8th of March 2010 is to proceed. 3, the question whether the child C give evidence at that hearing, and then in parenthesis, and if so, in what way, end of parenthesis, be remitted to her honour Judge Marshall to determine in the light of the judgment of this court. 4, there be no order for costs except for detailed assessment of publicly funded costs. And subject to anything which anyone feels obliged to raise straight away, we will return to this so far as necessary when the reasons are handed down tomorrow morning. Yeah, well, we are obviously very conscious indeed of all that needs to be done between now and next Monday, and that is why we thought it right, as we had reached a unanimous decision, to let you know straight away, and the reasons will be made available just as soon as we can. Thank you very much.